To officially start today, I'd like to invite Mara up to kick off today's session before we get rolling. So Mara is the Executive Director for the Canadian Chamber of Commerce, so welcome to the stage, Mara.
Good afternoon. Oh, that's a little high. Good afternoon, everyone. On behalf of the Canadian Chamber of Commerce in Vietnam, I am delighted to welcome you to the Vietnamese Legislation Case Study Seminar. The Canadian Chamber of Commerce in Vietnam, CanCham, has proudly served the business community for 25 years, fostering trade, investment, and partnerships between Canada and Vietnam. Our mission is to connect people, ideas, and opportunities, and today's seminar is very much part of that mission. We are proud to host this event in collaboration with the Consulate General of Canada in Ho Chi Minh City, and we sincerely thank the Consulate for their continued partnership and their commitment to advancing trade and investment between Canada and Vietnam. I would also like to recognize and extend our heartfelt appreciation to our national corporate sponsors for their year-round support to the CanCham community. Canadian National Railway, Danone Foods, Export Development Canada, Sun Life, Vina Capital, Grant Thornton, La Vie, Manulife, PCA, and Tilleke Gibbins. Your support enables us to create meaningful platforms like today's seminar, where we can exchange knowledge and strengthen collaboration across industries. I wish you all a productive and engaging afternoon of discussions. Thank you, everyone. Back to you, Mark.
Okay, so I got to do a little housekeeping before we get rolling here today. So just so everyone knows, you are on camera. This session is being recorded from start to finish. Secondly, if everyone could just take a moment to turn their phones on silent, if they haven't done that already, just so we have no interruptions. Got to raise that back up, Mara. And lastly, the panel discussions or the case studies that will be happening. If you have questions, just hold those till the end, and I believe that we'll open it up to the questions after each session. So. With that being said, we've got 4 top-tier firms with us here today. But before we jump into who's joining us and what that first session is going to look like, I'm going to introduce our moderators. We got Mike Herbert, who's the Country Commercial Director at Cognita Schools Vietnam. Mike is the Country Commercial Director of Cognita Group in Vietnam, a global leader in private education with 107 schools worldwide. In his role, he oversees the commercial and growth strategies of their 3 schools in Vietnam, the International School of Ho Chi Minh City, the American Academy, and the International School of Saigon Pearl. Those 3 schools are leaders in providing holistic education following the International Baccalaureate, I'm going to trip and fall over that word, Baccalaureate program at the AP diploma, or and the AP diploma. Mike is also the former president and chair, or president of Canadian Chamber of Commerce. Before moving to Vietnam, Mike had a successful track record in corporate finance in Canada with HSBC, Bank of Montreal, and Desjardins. Other than that, we have Ralph as well. Ralph is the founder and managing director of IFM Research. He's been in Vietnam for a very long time, 30 years. And after 20 years of corporate life, Ralph established IFM Research, Vietnam's first dedicated smartphone-based research agency with the largest consumer-based panel in Vietnam, offering full research services. Ralph set up TNS Kantar in 1996, including TNS Custom, TNS Consumer Panel, and TSN Media Forum 2010, served as regional managing director, TNS Kantar South Asia. That's a lot of TNSs. He holds an honors degree from Wilfrid Laurier University, which is only 45 minutes from where I'm from back home, and is an honorary board member of the CanCham, having served as president, vice president, and board member for over a decade. Okay, perfect. So our next panel discussion is going to be from Tilleke Gibbins. So they're going to share some practical and legal tips on lawful employee dismissals in Vietnam. A little bit about Tilleke Gibbins is they are a leading regional law firm with over 250 professionals across Southeast Asia. Active in Vietnam for quite some time, the firm is recognized for its strength in corporate and commercial law, M&A, labor and employment, and intellectual property with offices in Hanoi and Ho Chi Minh City. So with that, I'd first like to welcome Ralph to the stage as our moderator, as well as Sarah and Linh from Tilleke Gibbins. So while they're making their way to the stage, I'll tell you guys a little bit about Sarah and Linh. So Sarah is counsel for over 17 years of experience in Canadian and international law, with a focus on labor and employment, based in Vietnam since 2013. She is recognized by Legal 500 and Chambers for her expertise, and she has advised organizations from the ILO to multinational corporations, while also serving on CanCham Vietnam's board of directors. Linh is an associate. She specializes in corporate M&A and labor matters, advising clients across industries from technology to consumer goods. A licensed lawyer and member of the Ho Chi Minh City Bar Association, she brings nearly a decade of experience supporting international clients in Vietnam. So again, please welcome the group to the stage, and we're excited to hear the presentation.
First of all, just a quick one. Whoops. Just a quick one before we start. So Linh is representing Tilleke Gibbins, and Sarah is the client. Okay, so we can make this very clear from the get-go so we can follow it a little bit better, all right? So let me start off very simply by asking, can you give us a very broad brushstroke overview of what you're going to be talking about today?
Yes, so our topic today is about managing dismissals. This is a big challenge in Vietnam, so it's good for businesses to have some idea about this. So to begin with, just for people that are new to doing business in Vietnam, we'll give a very brief overview of termination. These are the simplest ways you can terminate an employee. If they are on a fixed-term contract, you can simply wait for it to expire. Your only obligation is to give notice before the expiry date, and the Labor Code doesn't specify how much notice, but we would recommend 30 days. When you bring on new staff, we recommend to put someone initially on a 1 or 2 year term contract, just in case it doesn't work out, and you can just let the contract expire. The other way terminations are often achieved in Vietnam is through mutual termination. In these cases, the employer generally proposes it, the parties sign an agreement with a comprehensive release, and normally it's necessary to pay a settlement payment or ex gratia payment to incentivize the employee to agree. If the employee does not agree to termination, there's a number of bases upon which the employer can unilaterally terminate them. So there's poor performance. If the employee provides untruthful information during the recruitment process, if the employee is absent from work for 5 consecutive days, redundancy, force majeure terminations, we saw some of these during COVID, and dismissal. And dismissal is specific to the case when an employee commits an act of misconduct, and that is our focus for today.
Yeah, I will continue our presentation. So we will focus on the dismissal section. And as you may know, the dismissal is limited in Vietnam, especially for the permissible cases that the employer can dismiss their employee, that we will discuss in further details in the next slide. For generally, the Labor Code states that the disciplinary action may only apply where the misconduct is listed in the register internal labor rules, the labor contract, or the labor law. However, practically, we observe that the competent authorities and especially the courts always prioritize applying the principle of the internal labor rules over the labor contract or the law. In case of dismissal, there is no requirement for zero allowance or notice. And the employer can only dismiss their employee in the following cases. As you can see on the screen, there are 4 cases. The first one, the employee commits act of theft, embezzlement, gambling, assault, use of drug at workplace, disclosure of the trade or technology secrets, infringement of the employer IP, sexual harassment. Just a critical note for this type of actions, there is no need to prove the financial damage when dismissing an employee. And for any other action that is not listed in the first point, the employer needs to prove the financial damage that caused or threatened to cause the serious damage or very serious damage to the employer. The third case is employee recommit the same action, the same misconduct or offense while they are still in the period of discipline action, or they recommit the offense after being disciplined by demotion. And last case, employees takes total of 5 days off in a month or a total 20 days off in a year without any proper reason.
So if you do have a legal basis for dismissal, it's still somewhat complicated. You need to hold a disciplinary hearing, and that means you need to send a formal invitation to the employee and to the representative of the executive trade union if you have a corporate level trade union, at least 5 working days in advance. At the disciplinary hearing, the employer presents the evidence. It's kind of like a little mini trial, and the employee and the trade union representative have an opportunity to respond. But regardless of their responses, the employer can make the decision at the end of the day. One thing to keep in mind is that very short limitation periods apply in Vietnam. It's only 6 months for most acts of misconduct, and the time begins to run from when the act occurs. This is a big difference from Canada and many common law jurisdictions, where the limitation period begins to run from the date of reasonable discovery, and it can be a big challenge. It's 12-month limitation period if the offense involves the employer's finances, assets, or the disclosure of confidential information. But again, it's from the occurrence of the act. So it can be very tricky, for example, if an employee has been secretly stealing money or something like that. If the 12-month period is over, the employer cannot take disciplinary action. So with that rosy picture, let's begin our case study.
Great. I'm going to hold off on the lawyer jokes until we get a little bit further into this, okay? Just to lighten the load. How many lawyers are in this room? Hands up. Wow, that's a lot of expensive salaries out there. All right. Now, yeah, exactly. So, just very quickly, so Sarah, as the client, what was the issue that you brought to Tilleke Gibbins?
Right.
Sorry, I keep getting that wrong.
I have a business consulting firm, and our work is very stressful. One of my employees, Bill, got in a heated argument with his department manager, Sam, and he threatened to kill him. He stormed out of the office that day, but then he returned the next day as if nothing had happened. So, obviously, it creates an extremely tense atmosphere at the office. Sam was afraid of Bill, and the other employees were also uncomfortable around him. We were concerned about Sam's safety and the other employees and how this would generally impact morale at the company. Our company had registered internal labor regulations. These are the official working rules of the employer that are registered with the Labor Authority. And they stated that committing an act breaching the law was subject to delay of salary increase or demotion, but nothing was specifically stated about uttering a death threat. We wished to immediately terminate Bill's employment. We had already requested him to resign, but he adamantly refused. So we wanted to proceed immediately with dismissal.
Is Bill's case typical, or is this quite unique in Vietnam?
This particular fact pattern is unique, But there are many cases that come up where there's no legal basis for dismissal. So for example, bribery is something that comes up from time to time when an employee has been engaged in corrupt conduct. It's a crime under the law, but it's not listed under Article 125 of the Labor Code. And it's only those listed offenses where the employer is not required to prove damages. If it's not one of those listed offenses, the employer has to prove that the conduct caused financial damage. And with something like bribery, that's very hard to show. Yeah.
Wow. Bribery is a big issue in Vietnam, as it is in a lot of Asian countries, but in Vietnam it's a huge issue. Now, from the client side, you've given what the real challenge is. From Tilleke's side, what was the biggest legal challenge for you to help solve and advocate for your client?
Well, to be honest, like Sarah just shared, this is not a common case in Vietnam. And also, the biggest challenge for the lawyer side, it should be advising the legal perspective and risk, and also considering the practical impact on the client. For example, the death threat, as you may know, the practical impact may outweigh the legal risk. So the client would not listen to our advice, but they try to consider and balance the risk from legal side and from the practical side. We just always want to advise our client that just don't dismiss any employee without any legal basis, because that would be unlawful and resulting in a really tons of thousands legal costs as well as the damage for the client.
Now, having said that, what were some of the suggestions, solutions that you offered the client? What were some of the things that you said, hey, consider this?
The solutions, there are two practical and also the best case scenario. The first one is to attempt to negotiate for the mutual termination first. So this is the best case scenario. From what we can see from the facts in the practice, employees they rarely met any claim for the mutual termination. And if the mutual termination can be reached between the parties, the company may consider apply a lower disciplinary measure, such as demotion.
So the first one was mutual agreed termination with some sort of severance payout and whatever else. The second one is demotion. What else did you recommend?
I think this is just two solutions that
So then tell me about demotion. What does that entail? How do you go about demoting someone legally?
Well, again, you need to have the offense listed in your internal labor regulations, which must be registered with the labor authority. And then in the internal labor regulations, under each disciplinary measure, you list the acts of misconduct that would be subject to it. So basically, if you wanted to demote someone, it has to be listed under demotion. And when you draft the internal labor regulations, you should try to draft the offenses broadly, because you can't anticipate everything. Because no one would probably expect one of their employees to be uttering death threats at the workplace. So you could have something like committing an act in breach of the law, or treating colleagues with disrespect, something like that.
Okay. It does sound kind of daunting, doesn't it? I mean, Vietnam is sort of known as being, remember, it is the Socialist Republic Communist Party of Vietnam, right? Which means typically labor rights are with the employee, okay? However, I've been here 31 years. Let me give you an example, all right, of something that you can use which is well within the law. We talked about demotion, okay? Now, I actually had a case, all right, where how shall I say? absolutely poor performance, not showing up, whatever, but I wasn't able to do much about it, okay? So what I did, this manager was responsible, not my present company is awesome, all right? But a former company that I work with. This person had 4 people reporting to her. And one was a very junior that just started with the company. So I promoted him to become her manager, okay? It lasted about a week before she resigned, all right? In Vietnam, there's something called Ngoc, face. So you can actually use face to your advantage, all right? So there are ways around, okay? There always are, okay? But I think, going back, the key here is you need to understand the law, you need to follow the law to protect yourself, because it is a market that is very pro-employee, yeah? What about, I mean, Bill is, my next question is, what about problem cases? Bill certainly is one. From the client side, what did you do? What was the end result?
Well, actually, in this particular case, we proceeded with the dismissal. There's a provision under the ILRs that said we could dismiss employees if they committed an act causing serious damage or threatening to cause serious damage. So we went on the basis that it threatened to cause serious damage. And our good lawyer warned us that that may not hold up in court because you would still have to show potential financial damage arising from the misconduct. And that could be hard to show in this case. But we proceeded anyways because the risk of safety to our other employees was so much of a concern, and it would totally impact their morale in the office. So we decided that the practical risks outweighed the legal risks.
Okay, so you let him go and then said, okay, we'll see you in court if that's the way you want to go.
Right.
Okay.
And
Did Bill see you in court?
Bill never brought a lawsuit, and it could be because uttering a death threat is a crime under the penal code. So he might have been concerned if that he's presenting his case in court, there's evidence before the court that he committed a serious crime. So I think that deterred him.
Okay. Now, you also mentioned something about employees who have protected status. Now, there's 2 parts. One is government, whatever people or whatever else. I don't think that really matters in this room. But could you tell us a little bit about that?
Yeah, sure.
Am I protected?
No, unless you're pregnant.
Yeah. There are certain cases for the protected status in terms of dismissal. The first type is the legally recognized leave for the employee, like annual leave, sick leave, maternity leave. If you're pregnant and raise a child under 12 months, so you're subject to the protected status. And the other 2 cases is if you are held by the legal authorities and have not been convicted yet. And the last case is you are subject to the ongoing investigation for the alleged misconduct.
But you can end up with some ridiculous results with protected status. So, for example, so keep in mind, pregnancy and raising a child under 12 months are 2 bases for protected status. So let's say you have a female employee.
Keep being pregnant.
She steals money from you, and then she immediately informs you that she's pregnant. You have to wait 21 months before you can take disciplinary action against her. And so what happens is after the period of protected status ends, the employer gets 60 days after that in which they can take disciplinary action. So you would have to wait out 21 months, paying as usual, except for, I guess, the maternity period where the state pays. But, yeah.
Don't hire pregnant kleptos? Okay. Then I just one other thing I want to touch on. You noted that what happens when an employer doesn't have the internal labor rules and laws set out? What protection do they have, or what can they do in case of a dismissal case?
Yeah, like I said, like we just discussed about the solutions. mutual termination and consider a lower measure of disciplinary action.
So even if I don't have labor,
Well, what we were saying before about face is very true. So in a lot of cases where an employer lacks the legal basis to carry out dismissal, they might have the legal basis to do demotion or something. And in that case, the loss of face often encourages people to leave.
oh, okay. Here's an interesting point. Recently, as you're aware, Vietnam went from 63 provinces to 34 provinces. And correct me if I'm wrong, Fred, you probably know this better than I do, but I think 6 ministries got folded into X number of ministries, right? And over 100,000 government employees were let go, all right? Now, if you work for the government here, you're very protected, okay? However, their job no longer existed because their workplace no longer existed, i.e. the ministry didn't exist anymore. So, for example, let's say if you have a production line or a certain part of your business, like let's say you have 3, 4 business streams and one of them goes under or whatever else, that is another way to potentially do that.
Yes.
But again, you
That would
still
be
need to follow the
redundancy.
law, right?
Yeah, that would be redundancy.
Okay, redundancy.
Yeah, so if you have a change in organizational structure, you can lay people off. It's you have to go through all the procedural steps, but you can do it. And then normally an employer would again propose mutual termination before going through all the redundancy steps, and then basically offer the employees what they would get paid under the redundancy, plus some extra as an incentive to sign the mutual termination agreement.
Before we go into the Q&A, I just have one final question for the both of you. For employers, all right, what is the single piece of really critical advice you can give when you're looking at dismissal of any kind?
Try to negotiate mutual termination first. Dismissal is very risky. Yeah, and it often results in wrongful termination lawsuits.
Okay.
So it's really worth making that effort to reach a mutual termination agreement.
Okay, awesome. Guys, first of all, thanks a lot. Let's give it to the floor. I'm sure there's lots of questions about Bill. $10. Hey, that was my first employee here.
Is it possible for, in this case, if as your consulting firm and Bill in this aspect, you said, no, Bill, we still really like you, and although this happened, we're ready to make you the head of branch in Pleiku. Could you move someone to another office that's really undesirable and know that they will not make that move?
They have to agree to that. So any changes to the labor contract, like job description or working location, have to be consented to by both parties, and they have to sign an amendment to the contract. So you would be breaching the labor contract, and if he refused to go, then you wouldn't.
What if his office or his desk magically gets moved to the cleaning closet?
Well, that is a good point, because the concept of constructive dismissal doesn't exist in Vietnam. In Canada, this is something employers really have to be careful about. Basically what it means is if an employer kind of makes the employee's working conditions unfavorable to incentivize them to leave, the court will treat that as equivalent to a dismissal. But Vietnam does not have that concept. So in some cases where it's really desperate dealing with an employee, sometimes they'll put the employee in an isolated office, and maybe they can find duties under their job description that are kind of undesirable, like filling out an Excel sheet or something, to encourage them to agree to leave.
Okay, any final last question? Jack? See, I know everybody's name.
Go Leafs.
Go Leafs.
Sarah, thanks for sharing. My question relates to the short-term limitation, 12 months after the act of occurrence. Mm-hmm. Well, what happens when the company only discover the act after the 12 months of occurrence? For example, a CFO committing embezzlement. Nobody really looks at that until you really need to look at that, right? Because CFO the only person who knows all the accounting stuff. You're out of luck if you're an employer. in that case?
Well, it's a crime. So basically, you could report the person to the police. And if they get found guilty of the crime, they'll be locked up, and then the contract is over.
But you can't fire the person on the spot?
No.
Okay, wow.
You're safe, Jack.
No, I'm not CFO, but I better look at the accounting stuff.
Okay, one final question, and then we'll have a break. Going once, going twice. Oh, over there. Somewhere over here.
Oh, actually, no.
Oh, you're just stretching? Yeah, okay, all right. All right, look, what time is it now, Mike? 4. Okay, 15-minute coffee break. Coffee's out there, coffee, tea. Please be back here at 4:15 for the last 2 sessions. Thank you.
But to close out today, I wanted to invite Mara back up on stage, our executive director, for some closing comments. So she's going to kind of wrap up there. And then after that happens, we're going to invite all of our panelists for today, our speakers for today, to come back up on stage.
All right. Thank you all for joining us this afternoon and for the thoughtful discussions and insights shared during the seminar. At CanCham, our vision is to support our members and the broader business community by providing connections, advocacy, and opportunities that help businesses thrive in Vietnam. Events like today's seminar are one way we fulfill that role, and by bringing together leaders, experts, and stakeholders to address key topics that impact us all. Whether it's through business seminars, networking events, trade missions, or community initiatives, CanCham is here to serve as a bridge between Canada and Vietnam, connecting people, ideas, and opportunities. I would like to once again thank our speakers, Mr. Trung, Mr. Vin, Ms. Valerie, Ms. Fung, Ms. Sarah, and Ms. Linh, and last but not the least, Mr. Jerome and Mr. Sandre. And our moderators, Mr. Mike Hubert and Mr. Ralph Mateus, and our MC, Mr. Mark Dickens. Thank you very much. We look forward to welcoming you at our future events and continuing to build a stronger and more connected community together. And once again, thanks to the Consulate General of Canada in Ho Chi Minh City, and thank you. Have a wonderful evening.